Blair.
Assistant Public Defender on behalf of Blair, who is approached. Mr. Blair, state your name for the record.
Cedric Blair.
Judge, we're asking for an adjournment in this matter.
You have his violation from the second.
I do, Your Honor.
Let's address that.
Okay. Your Honor, I do understand that the violation report indicates a number of missed tests as well as a number of positive tests on the SoberLink device. And I see also that there was a missed test on 129 and the test before that on the 22nd was positive. I've had an opportunity to speak with my client about this. Mr. Blair he was very upfront with me. He wants to be very upfront with the court. He has admitted that he has been struggling. He states that he has been trying to do this on his own, but it's clearly something that he cannot. I've spoken with him about all of the options available. We're going to ask, I do have on the printer, but I can submit.
Is he admitting to the violation?
He will be admitted to the violation.
Okay, go ahead. I'm sorry.
I do have a release to treatment order drafted up if the court would be willing to sign that. I've explained to him the benefits of a lot of the treatment facilities that Washtenaw County offers, or at least we're able to get him to. And he says that he wants to take a serious attempt at this. He's looking to reunite with his 18-year-old daughter, and he wants to be the best version of himself when he does that.
If I may, I'd also like to add that I have 2 different interviews coming up. And if it's somehow that I am able to walk out of here without going to treatment, I mean, treatment is definitely an option, but could we maybe, I would suggest an alcohol tether versus the SoberLink, because I have actually forgotten this in places before, which is why I missed a couple tests and whatnot. But that would be—
Well, the missed tests don't bother me as much as your positive test. And the SoberLink doesn't, or the Scram doesn't necessarily help with that. We got to find a way to get your addiction under control, and to really have you fulfill what your counsel's indicated is probably the most admirable thing you want to do, and that is be the best version of yourself for your daughter. All right. If that requires me to not let you walk out of here, that's what I'm going to do. Okay, because I think you want to do that. And I just looking at the best way to do it. You had a number of, you were really slipping. And I'm not, in saying that, I'm not saying that you weren't trying. I think that you were. You just have come to the realization you can't do it yourself.
I'd also like to add, if I may, another thing that for my stress is trying to find employment. And I have, like I said, I have an interview today at 1:00, and I have an interview at Biggs tomorrow. That was part of my stress and my basis for not coming to drop. I called the number, but if I didn't have the money, I didn't come. Because, I mean, I have to collect bottles just to get the bus fare down here for them to tell me, well, if you don't have the money, then you can't drop anyway. So it's like, it was a catch-22. So I was like, I've even put my applications in at McDonald's so I can at least have the money to pay for my drug screens. And there was no one to borrow from or nothing. Like, I have no one.
Yeah. All right. What I'm going to do is I'll adjourn this probable cause over to March 5th, 2026 at 9. At this point, based upon the violations and that he's admitted to those violations, I'm going to cancel the bench warrant that's out there. but I'm going to revoke his bond and remand the defendant to custody. I will sign the order regarding release.
Thank you, Your Honor. I'll have that submitted to the court right away.
I apologize, Your Honor. March 5th?
March 5th.
Yeah.
Defender Chelsea Virgil with and on behalf of Douglas Crockett, who appears via Zoom. Mr. Crockett, please state your name.
Douglas Crockett.
Thank you, sir.
We are asking to adjourn for a plea discussion, and we haven't received media discovery yet.
You have not received it?
No, Your Honor.
How soon is that going to happen?
Well, we're getting it over today.
Probable cause conference, March 12th.
Oh, excuse me.
2026.
Excuse me. Can I ask
Yes,
a question,
sir.
please, Your Honor? As far as my bond conditions, I wanted to see if I could ask in regards to where it states that I'm not able to return to the address 2129 Medford Road in Ann Arbor, Michigan. I wanted to see if that particular portion of it could potentially be lifted. That is my home address where I live with my twin brother, and I'm currently staying with my mother in West Bloomfield, and I work in Plymouth, and with doing my weekly drug test, having to come out to Washtenaw County and having to drive back, it's been very difficult due to the distance. And I was trying to see if possible, if that portion could be lifted.
Did you ask your attorney about that?
I didn't know I could ask.
Your Honor,
Know anything about that?
I didn't, Your Honor.
Probably not.
I would have
He
to
shocked us all.
consider it. I think he makes some valid points, Your Honor.
He does?
I would ask the court to consider his request.
Any response from the people?
Your Honor, we haven't had a chance to talk to the victim. It appears to be.
That's going to be the problem. Problem is, sir, you should have gone through your attorney with that. I don't mind listening to you. I understand what you're saying, but usually what will happen is you let your attorney know, which you've now done out loud. They then will let the prosecutor know, which you've also done out loud. The prosecutor will then talk to the alleged victim in the case, get their feelings on it, and then hopefully we can get it resolved. If they can do that and stipulate to something before the 12th, then I don't have a problem, I don't think, signing off on it. But in terms of your request right now, I'm going to deny it. I'm not going to change anything until all of the proper people have been contacted.
I understand.
Understood?
Yes.
All right. So I adjourn this out to the 12th, 9 a.m. Bond will continue. Thank you.
We're ready in this matter. Warren Brown, Deputy Chief Public Defender, affirm with and on behalf of Mr. Israel Crane. Mr. Crane, state your name for the record.
Israel Crane.
Thank you. Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination.
Discovery is all complete.
To the best of our knowledge, Your Honor.
All right. People would have their witnesses available the 25th. Preliminary examination in person, June 25th, 2024, 9 a.m. That is before Judge Washington.
Your Honor, I do just have one thing I would like to address with the court.
Yes.
So Mr. Crane was in Michigan because he requested to be supervised while being out for his conviction for armed robbery and FA out of Virginia. Agent Bennett, who I believe is supervising his release here in Michigan, notified our office this morning that he believes that the defendant is having contact with the victim through his mother. I do want to note that I don't see I was not able to find any jail calls to the victim directly from Mr. Crane, but I am concerned based off of the need that Agent Bennett felt the need to notify us of this. I have not had an opportunity to have a discussion with Agent Bennett with regard to this allegation or what the basis for it is, but I am concerned. I have not had an agent feel the need to contact our office to notify me of indirect contact on an
Okay, but are there then phone calls that would even remotely substantiate that, like phone calls to his mother?
Yes.
But the content of those particular phone calls, we don't know.
I have not had the opportunity to listen to them yet.
Mr. Byrne, I'm not sure what they're asking.
I think they're asking for his phone privileges to be revoked, but
They haven't said that he's had any contact. They haven't shown that he's directed anyone to do anything. We don't even know the extent of his mother's relationship with the complaining witness in this case. Without those facts, they're not asking for anything. They're just putting that out there.
here's what I'll do. Is somebody going to be able to listen to those calls to indicate? I mean, it's one thing if he's contacting his mother and his mother is then reaching out in some way, whatever, as opposed to him attempting to try to send messages through his mother. There's going to be a difference. So I'm reluctant to do anything until such time as there's some indication that that's what's happening in terms of a third party contact. So maybe if you get a statement from the officers to how they know that, what information has come to them, get that to Mr. Brown and to the court. I may change that decision so that you're aware, Mr. Brown, where if I look at it and it appears to me that that's the case, then I may revoke his privileges, and you can certainly have a hearing before Judge Washington or this court regarding that. Okay. So I think that's probably the best way at this juncture to handle it. Court calls the case, People versus Deshaun McFarland.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. McFarland. Sir, what's your name for the court?
McFarland.
In this case, Your Honor, we're asking the court to please set for exam. Discovery should be complete.
That is correct, Your Honor. Discovery.
People would have their witnesses available the 25th. Preliminary examination, June 25th, 2024, 9 a.m. before Judge Washington.
Your Honor, there is one matter.
Of course you would. Go ahead.
Your Honor, I do want to note that there have been no calls directly to the victim. However, I do have notes that, and I did notify Mr. Bernstein of this, as well as request to have the jail clothes released to him, that the defendant has been talking to his grandmother and informing and instructing her to contact the victim about dropping the PPO. I am extremely concerned. This is not an isolated phone call, but it seems to be repetitive and continuous and come up in multiple conversations. As a result, I also want to follow up and say that it does appear that the victim was contacted by the grandmother, according to later conversations, and that she said she would not be dropping the PPO. She wants to keep it in place for a year and see how he does. But at this point, it's not just a request for indirect contact, it is successful indirect contact. I would be requesting for his phone privilege.
Well, it certainly hurts the bond argument that I was planning on making today, Your Honor. I don't have a response. Let me give that.
Well, I'll just say this. I'm a bit concerned that the contact was made. And that the contact that's made is of a nature that is obstructive. It wasn't just, hi, how you doing? That concerns me. So two things are going to happen here. Defendant's phone privileges are hereby ordered revoked. Defendant's bond is also increased to $200,000 cash surety.
You gotta stop. I'm sorry, I can't say this.
Thank you. Versus, is it Hazel Jacobs?
Assistant Public Defender on behalf of Hazel Jacobs, who approaches.
Take your name.
Mr. Jacobs. Thank you. Your Honor.
Yes.
I'm so sorry. Just looking for my notes on this one. I do know that, Your Honor, if we can be heard on bond after this, I would be appreciative. And I understand that there is an alleged violation that we need to go over. We would like to. You want to waive or hold your exam? I tried to get a hold of my client, Your Honor. I was not able to explain to him because we didn't know that he was in the jail until late yesterday. So I have not been able to talk to him. I would ask to adjourn this for 1 week so I can go over everything with him and explain exactly what the next options are. So if we could just get 1 week, that'd be. I wouldn't.
June 20th, 2000.
Not right now. Please stop talking. Listen, I have the information.
June 24th, 2020, June 20th, 2024, 9 a.m. for probable cause.
Thank you, Your Honor.
This time you didn't want to address bond, did you? I have a conditional violation. If you want to address it, you can go ahead, but.
I understand, Your Honor. As it pertains to the conditional violation, my client would have me advise the court that with regard to the report that the court is in receipt of, the argument involving the subject of the no contact order, which was heard by his neighbors, occurred while he was not home, occurred while the individual he has the no contact on was arguing with someone that she was talking to the phone on. He advises that she was at home without his knowledge and that he came home to find her there. It advises that the ensuing argument resulted after she started screaming and crying when he asked her to leave so he wouldn't violate his conditional bond, Your Honor. Additionally, he advises that he has orientation for a new job next week and he will be unable to gain income used to support his father and child if he loses that new job, which will happen if he does not attend that orientation. So he would be asking for a release based on the information that the court's in receipt of.
Response from the people.
He was home. He told the police that he was home. He actually told the police that she's the person he was arguing with. He actually went on to tell the police that he's the person she was yelling at. I'm not sure why he doesn't remember talking to the police. I'm not sure why he doesn't know that the police would write a report to that. That all of us have this report. All of his admissions to be and having contact with her. So yes, this occurred at his apartment. However, he was there. The police spoke with her and spoke with him. And the police arrested him for having contact with her. And that's when he went on to admit to them that he was in an argument with her, that she was screaming at him. And he acknowledged the no contact order with her. So that's the conditional violation. The other reason that Your Honor should continue the defendant's bond as it currently is ordered is because when my office charged this case, we requested 25,000 cash surety on this. And we're not given that information. This is a case where the defendant is charged with strangulation. It reported to the police. The defendant was punching her in the face, got on top of her, while she was laying on her back on the bed. The defendant was on top of her, pinning her arms on the bed and using his other hand to choke her. She told the police the defendant squeezed her throat with his hand and then started using the blade of his forearm, so it's the bone there, to apply pressure to her throat. She said she punched him in the face in an attempt to get him off of her, and that she felt that she was being choked for approximately 30 seconds until she struggled to breathe. The police noted in their report that the victim's throat was covered in scratch marks and light red bruising. She indicated she did not lose consciousness, but she had to fight him off on her bed. And then the defendant, while she was trying to fight him off of her, the defendant went on to fight her right shoulder. The police officer wrote in the report, "I observed what appeared to be an obvious bite mark on her shoulder, visible teeth marks and bruising." It goes on. The victim continues to report that even after that, punching her in the head, the officer does a great job of, as she's reporting what occurred to her, keep that in his next statement. He's on to report what he observed. He says, I observed raised bruises or goose eggs on the side and back of her head. And it continues. So, Your Honor, we requested 25,000 just based on the facts of this case alone, as well as the danger that the defendant presents to not only this victim, but the community. But then he goes on to have contact with her, make admissions to the police, and come before Your Honor and try to tell us a different story. So I'm asking that Your Honor not reduce bond in any way this time. Thank you.
Your Honor, may I respond to that?
No.
Your Honor, as it pertains to the allegations of the alleged crime here, a determination was made by the magistrate as to his release. He was out. We don't deny, as it pertains to the allegations on the bond violation, that any of that happened, other than the fact that he arrived home from a haircut and she was there and he tried to get her to leave, so that he wasn't in violation of that bond condition. He advises that he has a tether. He's willing to do home confinement. We just would ask for consideration and his release.
Now, he was brought in on the conditional bond violation. It was not arraigned before the magistrate on the conditional bond release.
I'm sorry. I didn't mean to cut you off. I'll stop talking.
Go ahead. What were you going to?
I was just with regard to the original charges, Your Honor, not the bond violation.
Right.
Okay.
Taking all that into account, what the story that just relayed to me doesn't match the police report at all. In regard to what the defendant is having counsel put forth to the court.
Okay.
Because of the conditional bond violation, taking that into account with the allegations, at least as it regards this particular case, the court's going to set the defendant's bond in the amount of 50,000 cash surety. And we'll see him next week.
Thank you, Your Honor.